In this screencast, we'll discuss indigent defense, what it means, and what the requirements are in accordance with the Code of Criminal Procedure. An indigent defendant is one who is not financially able to employ counsel as determined by a judge. So this doesn't necessarily mean they're homeless. It just means a judge has determined they don't have the financial means to hire a lawyer. Approximately 80% of defendants in our criminal justice system are considered indigent. Indigent defendants are entitled to have an attorney during any judicial proceeding that may result in confinement, so jail or prison, or any criminal proceeding if the court determines it's in the interests of justice. This is for all offenses except C misdemeanors. Now, interest of justice means a judge has the discretion to appoint a defense attorney to ensure due process. Because an indigent defendant is dependent on the government to appoint an attorney, the state sets time limits to ensure they don't wait too long in jail. Let's review those time limits. If an indigent defendant who is arrested on either a warrant from the county they are in or without a warrant is entitled to counsel and requests counsel be appointed and adversarial criminal proceedings have been initiated, in a county of less than 250,000 people, counsel shall be appointed as soon as possible, but not later than the end of the third working day after the court receives a request. In a county of more than 250,000 people, counsel shall be appointed as soon as possible, but not later than the end of the first working day after the court receives a request. If an indigent defendant arrested on an out-of-county warrant, in other words, he's arrested in County A on a warrant out of County B, and he's entitled to counsel, requests counsel, and regardless of whether or not criminal proceedings have been initiated, a county that issued the warrant of less than 250,000 people shall appoint counsel as soon as possible, but not later than the end of the third working day. Or, if the county that issued the warrant has more than 250,000 people, they shall appoint counsel as soon as possible, but not later than the end of the first working day. Now, if the county which generated the warrant neither assigns counsel nor transfers the defendant to their custody before the 11th day, in other words, if they don't do what the Code of Criminal Procedure says they're supposed to do, the county where the arrest was made shall immediately appoint counsel. Now, this all might seem very confusing, but just remember, less is more. A county of less than 250,000 people has 3 days to appoint indigent defense. A county of more than 250,000 people has 1 day to appoint indigent defense.